California has what's called a limited conservatorship for an individual who has a developmental disability. California uses the term conservatorship. Other states refer to these as guardianships. But in California, conservatorship is for somebody who's over the age of 18. Now, the reason we have a limited conservatorship is someone with a developmental disability, when they turn 18, they are an adult in the eyes of the law. That means they can enter into contracts. That means your parents aren't allowed to talk to your doctors anymore in a strict legal sense. Your teachers or school officials don't have to talk to the parents once the child turns 18. So where we have a limited conservatorship, we want to have parents given the control to make decisions or to continue making decisions on where is my child going to live, what are the educational opportunities that are available to my child, what are the medical decisions that need to be made. So it kind of is limited to those key areas for their child's life. And it's a little simpler and more streamlined than a general conservatorship for an adult, which we typically think of as an older adult who is having issues with capacity such as dementia. Well, it is a court approval process, so there is some complexity to it. When you file a petition to become a conservator, the court wants to know about who you are, so there's some confidential forms you have to provide so that the court investigator can do a background check on you to see that you're appropriate to be a conservator. The court will also hire an attorney to represent your child and make sure that the conservatorship is in their best interests. In California, we have something called regional centers that provide services to individuals with disabilities. And so the regional center also writes a report and chimes in on whether it's appropriate, in their view, to have a conservatorship. And there's also a doctor that has to fill out what's called a capacity declaration to tell the court whether or not this person does have a developmental disability or not, and what the deficits are, and so the court can get a more complete picture of whether a conservatorship is appropriate. One of the things that's important to know about conservatorships is that, when you get a conservatorship, you're taking away someone's civil liberties. So it's not something we want to do lightly. That's why we have all of these actors in these different roles who are providing reports to the court for that protection. And we're not talking about, this isn't a Britney Spears type situation, but, we are taking away someone's civil liberties. And so that's why we try to provide these protections. It generally takes 4 to 6 months to complete a conservatorship. And one of the reasons for that is all of these reports that I've been talking about. It takes time to get these different agencies to complete their reports and submit them to the court. So typically, there's an initial court appearance, but not all the documents have been filed and submitted. So we have to have a second court appearance, and so that's why it goes from about a 4-month process to a 6-month process. Now, certain counties are better than others. So I find that often in Contra Costa County, we can complete the process in less time and with only 1 court appearance than we can in other counties. The conservatorship process for limited conservatorship is handled on a flat fee basis. The cost, though, can depend and vary from county to county. Contra Costa County in particular charges an additional $800 court investigator fee up front. So the parents have to pay the filing fee of $450 plus another $800 court investigator fee. So just the court fees to start a conservatorship are over $1,200. And I use a flat fee for all of my legal services to do that. That fee doesn't change no matter how many court appearances are required to complete the process. And I think it's important to give families that sort of security in knowing, again, that there's only one fee. It's never going to change. They don't have to worry about every time they call the meter's running. Or every time we go to court, the meter's running. I always feel that I'm the expert in this situation. I know what's needed to get these petitions approved promptly and quickly. And so if it's not being approved the first time up or the second time up, that's really on me. It's not on the client. There shouldn't be any additional fees for that.